on the slopes of Diamond Head. This is Kapiolani Community College. Kulia ika nu'u, strive for the highest.
Aloha, I'm Ben Carroll. Welcome back to the legal environment of business, Business Law 200. Last time we took a look at dispute resolution, some of the ways to handle a problem without going to court, since we've already looked at the court side. And so this time we'll do a little review, and then we'll start looking at how to understand the law. Okay, we always start out with our review. So what are the chances that your lawsuit will reach a final judgment? Well, as we talked about last time, most disputes never even have a lawsuit filed. In other words, your average fender bender, a problem with a neighbor, that sort of thing, you do not go to court. So despite the things we read in the paper about what a litigious society we are, people suing everybody, not really the case. Most of these things get resolved without filing a suit. But even if we do file a suit, in other words, for whatever reason we decide to file a complaint, start a lawsuit, how many of those will actually go all the way through the trial process and end up with a judgment? Less than 5%. So we really don't see that many cases going to court. It's resolved other ways, and that's what we looked at last time. Okay. If you become involved in a personal or business dispute, what's the first thing you would do to try and resolve it? Well, I hope this is obvious after our last session. Talk about it. Work it out yourself. You know that you're not likely to need to go all the way to a court judgment, so start early, try and take care of it. Now remember, we did have a warning about do-it-yourself justice. So when we talk about taking the law into your own hands, there's certainly some risks there. But with respect to negotiating, working with other folks, that should do the trick for you. Okay. What are some of the problems in using litigation or a lawsuit to resolve your disputes? And when might a lawsuit be your preferred choice? Okay, well, I hope it's evident by now that a lawsuit has a number of drawbacks. In general, it's going to be much more expensive. So you remember we looked at kind of a continuum where we have negotiation on one side, we go through mediation, arbitration, we finally end up in court. And as we progress from working it out yourself to actually having the government involved, we can see some things happening. So as we go along this continuum, we get more formal, and more importantly, the expense starts to go up. Because litigation is expensive. We have filing costs when we file our lawsuit. We have expert witness fees. We have costs to take a deposition for the court reporter. And of course, we have attorney's fees. So it gets more expensive. So that's a drawback, certainly, for litigation. Many matters simply aren't worth taking to court, which is why we have small claims court. And some matters are even too small for small claims court. It simply isn't worth your while financially, because even if you win, you may end up spending more to win than letting it go. What are some other drawbacks? Well, we talked about the time it takes to go to litigation. So it will take you 1.5 years or more to have your lawsuit go from the time you filed until you get a judgment. So many kinds of problems can't take that long. If you got a contract dispute, if you need something to happen right now, 1.5 years later, doesn't make any difference. That problem's done. So that's not an adequate solution. What's another cost? Well, this is a little less obvious, but we talked about the emotional cost of taking a matter through litigation. Again, it's an adversarial process, so you are, in essence, battling with the other side. So for many types of disputes, if you're going to have a continuing relationship with someone, this isn't your best bet. Okay? Now, Those things all go up as you go to litigation, and on the other hand, some things go down. And what goes down, what is reduced, is your ability to control the result and your ability to fashion a creative, non-legal kind of solution. So as that progresses, you lose the ability, because over here in the negotiation or mediation, if you don't agree, you don't have a result. Whereas over here, you're going to get a decision whether you want it or not. Okay. Now, again, there are some instances where a lawsuit makes sense. So if you want to establish what the law is, you may need to do that with a lawsuit. If you keep settling cases, if you keep having other kinds of dispute resolution, you won't have a determination by the court what the law means. And that may be important to you. It may be important to you even if you don't like the result, but at least now it's predictable. You know, so you can plan your affairs accordingly. There may be instances where you simply aren't willing to settle because this is a matter of principle to you. This is something that's so important that you would risk finding out what the court says, but you're certainly not going to back off on your own. Again, it may be a value choice. It may be something moral for you, something of that kind. So there are instances where we want to use the court process, and it may be our best choice in those instances. Okay, some differences between mediation and arbitration, and how would the parties get involved in these types of processes? Okay, as you recall, mediation, another description I like to use is assisted negotiation. So mediation is having somebody help you come to an agreement. Again, the agreement is yours and the other parties. It's not the mediator's. The mediator has simply facilitated or assisted you in making that happen. So just as in negotiation, if you don't like the result, you can walk. It only becomes enforceable, it only becomes an agreement when you agree to it. And then, of course, it may be contractual. But in any case, you have the option of not agreeing if you don't like the result. Now, most arbitration, again, we have a third-party neutral, an impartial third party assisting us, but we have given that neutral, the arbitrator, the power to decide. So in an arbitration, we will end up with a decision. And this, of course, is much closer to litigation, where we have a judge giving us a decision. Now, again, there are on occasion there is non-binding arbitration where we would get a decision, but we wouldn't have to follow it. But that's really not the norm. Usually when we use the term arbitration, we're talking about binding arbitration where we've agreed that we will abide by the result. Okay, now how do we enter into these types of processes? Well, sometimes it's actually in a contract. So you may look at your some contracts that you're involved in, even perhaps with a medical provider, and you may find that you have agreed to arbitrate or mediate your disputes. So you may have agreed contractually to do that. Obviously, if a problem comes up with another person, then you can both agree at that time, we would like to take it to arbitration or mediation, try these out before we end up in court. And then finally, the court itself implements various ADR processes because they want to both clear cases out of court and also feel that in certain instances, these are better ways of handling the disputes. Okay, how do courts encourage ADR, and what is CAAP, CAP? Okay, well, our courts in Hawaii are in the forefront of providing ADR, and so there's numerous places where they will encourage or mandate, order ADR processes. So we talked about the small claims court, which has mandatory mediation, and that means if you go to small claims court, the judge will send you out to talk to a mediator before the judge hears your case. Okay, in circuit court, our main trial court, at various stages, you need to indicate to the court that you have tried to settle the case so that you have engaged in ADR. And it even goes up to the appellate level. So there's an appellate mediation program where you've actually gone to court, you've had a trial, you've had a judgment, and someone has appealed. And even at that stage, the court may ask you to go to mediation to see if you can settle it, even though it's already gone through an entire litigation process. a number of those cases will still settle at the appellate level. So at these various stages, the court is going to encourage and or order you to be involved in ADR processes. Now, CAP was the state program we talked about, court-annexed arbitration program, and this takes a lot of cases out of the court system, and it does this for cases worth $150,000 or less, and it takes those cases away from the court and sends them to an arbitrator. Again, this is not voluntary. If your case fits within the program, you are sent to have your case heard by an arbitrator that's an experienced attorney. Now, since they have taken away your right to court, so to speak, at the end of the arbitration, if you don't like the decision, you do have a right to go back to the trial process. However, there's a proviso there. If you don't do 30% better than your arbitration decision, then you have to pay all of the costs of the other side. So it's pretty effective. Most people will not go back to court unless they have a real good feeling that they're going to do better. Otherwise, they may pay more than they win. Okay, we talked a little bit about administrative law processes. So what do we mean when we talk about department and agency functions as being quasi-legislative and quasi-judicial? Okay, remember, agencies most of them are part of the executive department, so they're part of the enforcement arm, so to speak. But the departments and agencies have a lot of power themselves. So some of the rulemaking, lawmaking power has been delegated by the legislature or Congress to the departments and agencies. So they're able to make their own rules. And when they make these rules, they have the same force as a statute. They also will implement their rules. For example, I think we used a worker compensation example. So they will come up with the rules of how employers report injuries, who qualifies, that sort of thing. Then if there's a problem, if you don't like the decision that the board has made on your particular case, then you have a right to have a hearing and a trial, so to speak, a hearing. And this looks a lot like what would happen in court. So that would be the quasi-judicial. When they're making the rules and regulations, that's the quasi-legislative. So they have a lot of power in both making the rules, interpreting the rules, and enforcing the rules. And we talked about some of the checks and balances. So they do have to follow the Administrative Procedure Act and their own enabling act, the act that set them up. And there is a fail-safe at the end that you could appeal a final decision. But again, a lot of deference is given to the departments and agencies. So a lot of matters are going to be handled that way rather than litigation. Okay, what happens when a lawsuit is settled before trial, and what is a release? Okay, if you have actually filed a lawsuit and you settle it, you need to let the court know. So then the court will dismiss the suit. So that's letting them know process can stop, we're done. Okay, and a release is simply a contract you have with the other side where your liability is being released in exchange for money. And so that's how we actually settle it without going to court. Okay, so today we're going to look at how to interpret the law. So we found out where the law comes from. We found out kind of how it's enforced, different processes to resolve our disputes and to do our business. And now we're going to look at how to actually interpret the laws that come from the various branches that we've talked about. So our agenda is going to be starting out with understanding statutes. We're going to talk a little bit about legislative history. We're going to see what uniform laws are. And we'll actually look at reading a case, because cases are actually a little more involved than the law. We hope the law is going to be rather plain or plain language, with, of course, the exception of the Internal Revenue Code and some other similar type laws. But reading a case takes a little bit of practice, and so we'll look at how to do that. And then we will discuss how cases help us interpret and apply the statutes. So again, in our common law system, what the court says about statutes is important. Okay, so when we look at statutes, what do we know about statutes? Okay, statutes come from the legislature or Congress. Their power has been given to them through the Constitution. And we know a little bit, you've seen the materials on the website, where we start out as a bill, in other words, a proposed law. It is given to appropriate committees. They will do some research on it. They will hold some public hearings, see what the public thinks about the bill. They will very often issue committee reports that explain what the purpose of the bill is, why we're making certain changes, what we've heard from interested parties that may incorporate it in it. And then at some point, a Senate bill will be sent over to the House, and a House bill will be sent over to the Senate if they're still going. There may be more committee reports, and eventually, if both houses agree, then it will be passed as an act, and it will then be looked at by the executive. So the president or the governor will have a chance to sign off on it or veto it. And if it's veto, it's possible that it can be overridden. Only at that point it becomes a law, and then it's entered into the appropriate place. So it would be entered into the United States Code if it's federal, or could be introduced into the Hawaii Revised Statutes if it's state. And recall that we also have local bodies such as city councils, county organizations that would pass ordinances. So any of these laws, when they're finally passed, end up in the appropriate place. Okay, let's take a look at a particular ordinance, and we'll see how we interpret this. So you can see here we have an ordinance, and this says there's a $50 fine for leaving trash on the beach. So very short, seems pretty clear, right? $50 fine for leaving trash on the beach. Might define this as a littering law. Okay, so we want to see what constitutes a violation of this law. So let's take a look here. We have some people leaving a number of items on the beach. And we want to determine who should be charged with violating the law. So you can see initially we have a diamond ring here. So what do you think about that? What did the ordinance say again? $50 fine for leaving trash on the beach. Okay, well, looks like the beach there, right? Sand. What do we think about whether or not this is a violation? So think in your own head, violation or not a violation. If it's not a violation, why not? Okay. Let's consider some other possibilities. Okay, we have a Coke can left on the beach. What do we think? Coke can, $50 fine for leaving trash on the beach. Now, when we were looking at the diamond ring, I suspect a number of folks said, well, I don't think a diamond ring is trash. Okay, so that's not sure that's trash. And another thing you might have thought is nobody would leave a diamond ring on the beach, so that was forgotten. Somebody didn't mean to do that. So we look at whether or not there was intent, and we're also going to look at value. You might look at the Coke can and say, well, Coke can's not worth anything, but remember, now we have 5 cents. It's worth 5 cents, isn't it? So I don't know about you, but many occasions I've left a Coke can someplace and it vanishes before I could even get it into the container because somebody's collecting it for the refund. Okay. What do we got next to this? Well, somebody's painted on a rock. So what is that? That's graffiti. Okay. Now, did the graffiti artist, so to speak, violate this law? The law says $50 fine for leaving trash on the beach. Okay. Now, what has been left here? Well, frequently people will say, well, nothing's left there. But really there is, isn't there? There's what's left. There's some paint left there or some kind of material that's marked. And I suspect you have the same thought that a number of folks do. Well, we don't like what they did, but we're going to charge them with something else. Got to be a graffiti law, so we don't need to do a littering law. It doesn't seem like a good fit. We're going to charge them with a graffiti law. Okay. Well, we're not interpreting the graffiti law at this point, are we? We're seeing whether or not this would qualify as leaving trash on the beach. Okay, so that may be a judgment call for you. They've certainly left something. Again, Our inclination is we probably are going to have a better law to cover this, but again, you can be charged with a number of different things, so they could be charged with several violations, and our question would be, do we think this qualifies? Okay, let's look at some other possibilities. Okay, here we have some clamshells, and we have a paperback book. Okay, so looking at the clamshells, what do we think about the clamshells? Are they trash? Again, we got a definitional issue here. What do we think is trash? Now, some people are a little less offended by the clams, and why do you suppose that's so? Well, they say, clams on the beach, that's kind of a natural thing. That's what we'd expect to find, clams on the beach. So maybe that's not, it's a natural thing. It doesn't look as bad, etc. Okay, but remember, maybe these are those foreign clams from Maryland. These aren't opihi. So these are different kind of clams. That's not naturally where they would occur. Yeah. Another possibility is, what if they still have food material on them, part of the clam itself, and they're kind of getting nasty, drawing flies, vermin, etc. So kind of a health issue. Another possibility. And how about the paperback book? Well, here again, we're talking about value. So paperback book, would it be different if we had a first edition still wrapped up in a leather notebook or something, which was clearly of much greater value? Would that be different from a paperback book that's kind of scraped up or whatever? Okay, well, we've come up with a number of kind of different questions we have here. And what would help us? Okay, well, it would help us to know what we mean when we say trash, wouldn't it? And it would help us to know what we mean when we say left. And there may be some other words. Okay, so that would be useful to us, because trash, when we first look at it, sounds like we may know what it means, but maybe not. Maybe we don't have enough of a definition to help. What else? The purpose. What is this law meant to do? Is it to keep the area nice because of tourism? Is it to prevent health or safety problems, something left that could harm somebody? What is the purpose? And it might have several of these purposes. And how would we know what the purpose is? Well, the purpose might actually be stated in the law. It might say, this is a law to do X. It might be in the title. Okay, so it may be law for something. It may be clear to us where the law is in the statutes. In other words, if it's in the health and safety part, that's one thing. If it's over in tourism and economic development, that may mean something else. And then we might look at what the legislature says. As we talked about, when they pass the law, they will be discussing what they're trying to do with it, and that may be helpful as well. Okay, so definitions are going to be important to us in the law, because the words don't necessarily mean the common understanding. For example, if we had a law that referred to family member, what does that mean? Is that your blood relatives? Is it a certain quantum or whatever? So there could be different definitions that would be important to us if we're going to know who the law applies to and who it doesn't. Okay. In Hawaii, we have Hanai adoption, so it's not even a formal adoption. There's a relationship. So many of these terms are not, the common dictionary understanding isn't good enough. When I saw this trash, I wondered, is there a distinction between trash, garbage, rubbish? I don't know. Trash seems like, well, maybe that's dry. Garbage, that's the nastier stuff. You wouldn't call it trash. Rubbish, maybe that's the stuff we clean up in our yard. But again, we don't know, and our common understanding isn't good enough. Okay? There may be other things we need to define, so we'll consider that as well. The legislative history, again, may help us. So the legislative history technically would refer to everything that occurs before it becomes a law. So it would, when it's introduced, when they have public hearings, anything that's submitted by people that are interested in the law, they may submit testimony, they may submit documents or reports or studies, and the legislature itself may have studies done. So there may be a whole lot of information that's put into this process where it becomes a law. But for the most part, when we think of legislative history, we think of our committee reports. So those are where the committee that's involved actually states what the purpose is, why we're making the changes, what the provisions are. So this is really the most valuable part of our legislative history, even though technically legislative history would encompass everything that went on. So again, when we think of legislative history, generally we're going to be interested in committee reports. Okay, so now we get to where the court's involved. So let's look at our trash ordinance again, $50 fine for leaving trash on the beach. And let's say that we have an instance where someone has left something on the beach and indicates, yes, it was trash, but I didn't do it on purpose. I didn't leave it on purpose. And the court in this instance might look at the legislative history, might look at the statute and say, we don't see anything in this statute, in this ordinance, that says it has to be intentional. If it had said throwing, or if it had said something like that, maybe we could interpret that to mean that you had to intend to, but it just says leaving. So the court may decide, for us, leaving means leaving. You're gone, it's here, that's leaving. Whether you intended to or not isn't important to this interpretation. Now, how would that help us? Well, remember when we were talking about the diamond ring, we said, well, nobody would want to leave a diamond ring. That's got to be an accident. That's got to be unintentional. But if the court said intent doesn't matter, where are we now? Well, that means we don't need to show that it was unintentional. Now, of course, it could be somebody could leave a diamond ring on purpose. So it could be that two-timing, no good, blankety blank, whoop. So somebody could intend to leave a diamond ring, but what this court decision says is we don't care. It's not important. You're gone, it's here, it's left. Okay. Now, we did have a question about trash, and I think pretty clearly we're going to agree trash is a term that needs to be defined. Because what has absolutely no value? Is there anything that has no value? Probably some things, but you've heard the saying, one person's trash is another person's treasure, so that's kind of a value judgment. It would be useful to us to understand what trash means. Might be hard to define, but you know our littering statutes do that. And then finally, I'll just throw this out. It says on the beach. So we might need to define what we mean by on the beach. What if we stick it in a bush? It's not on the sand. What if it's on the grass in the beach park? And in Hawaii, we have some definitions. Since we have so much beach property, we have some definitions about high water mark, vegetation, etc. So we may even need to define beach. So again, quite important to make sure that we're all talking the same language when we're defining our terms. Okay, I want to talk a little bit about uniform laws. Okay, now, so what is a uniform law? Well, as it says, uniform means standard, and so the idea behind a uniform law is it's going to be the same across the country. Okay, so there's something called the National Conference of Commissioners on Uniform State Laws, and each state has a couple of representatives that go to NACUSL, and they look at laws they think should be the same across the country. An example is UCC. We'll discuss that in a minute. So they propose laws, and these laws are only actually valid where they are adopted through the regular legislative process. So NACUSL or other national organizations, for example, American Law Institute, or other national organizations can propose laws that they think should be standard, should be uniform across the country. And if you think about it, a lot of things we would want to be the same from state to state. Each state can pass its own laws. We've talked about it before. Capital punishment one place, another place doesn't agree. But certain kinds of laws make sense to be the same. And one of the laws that has been passed by all the states is the Uniform Commercial Code. And we'll be dealing with that in a few sessions. The Uniform Commercial Code deals with all of our commercial or business transactions. So if you write a check, use a credit card, deal with your bank, buy something, sell something, it's all covered by the Uniform Commercial Code. And if you think about it, if we sent our check or our credit card payment to another state and it was handled differently, we'd be in a real mess. So that's why Uniform Commercial Code was one of the first uniform laws adopted by all the states. Now, for quite a few years, Louisiana wasn't fully on board because remember we talked about Louisiana was a civil law jurisdiction rather than common law, but they've adopted major parts of the Uniform Commercial Code. So we now have Uniform Commercial Code across the country. Now, when you adopt a uniform law, it still goes through your process. So it's not valid in your state till you pass it. And when you pass it, you can make changes. And sometimes they do. So as long as it's pretty close, we still may call it the uniform law. But it can be tweaked and there can be additional provisions put in by a state. So why is that useful to us? Well, there's a couple things happening here. One is these uniform laws take a long time to develop by these kind of legal think tanks. And so they're usually very well constructed. They fit together, no glitches, well-defined, and a whole lot of information about how and why they were passed, why the provisions are what they are. So if we're interpreting a law, and our law is a uniform law, in addition to our court cases, we have a whole lot of other material that will tell us what the law means, why it says, what each of the terms mean. So it's very useful to us if we have a uniform law because we have a lot more explanation of what's going on. Now, by the same token, if we know where our law came from, in other words, if we have adopted a law from another state, it gives us some of those same benefits. For example, in Hawaii, our no-fault motor vehicle law, it's actually a modified no-fault, we have based that on the Michigan law. So if we have questions about how to interpret our law, we might first go to Michigan cases if we don't have any and see what they say. Because if it's the same language, came from the same place, then that will be useful to us. Again, if it's from another state, it's not binding on us, but it may be very persuasive to us. Okay, when we talk about applying case law, I want to review very briefly, we're talking about appellate cases. Okay, so if we go to trial, like the video we saw, at the end of the trial, what do we have? We have maybe a single sheet of paper and it says, Ms. Garcia has judgment against Mr. Hansen in the amount of $547,000. That's it. That's the end paper for that lawsuit. So if we're not part of that trial, if we're not Ms. Garcia or Mr. Hansen and we didn't see the trial and we see that piece of paper, we might not even know what kind of lawsuit that is. So that paper record isn't of any value to us. Now, could we find out what happened in the case? Sure. Most cases we could go down and we could read the court files at the court, see what's happening. Some states even have this online. But we don't have a single paper that tells us what's going on. Okay, now, appellate decisions are going to be different. Okay, so the appeal is done entirely in writing. So we don't have witnesses, we don't have evidence. Everything is written up when a case is appealed and presented to the appellate court. Okay, they may allow half-hour argument by the attorneys to explain their writing, but generally everything's based on the writing. So you're not presenting anything new in your appellate case. You're simply looking at what went on before. And since it's all based on the written record, the appellate court is going to explain what was presented to them, what happened, what they think the law is, etc. So they're going to give us the full story. Another thing to remember about the appellate cases is this is our highest court, okay, an appellate court. So the lower courts have to follow it. So another reason we're interested in appellate cases is because if our Supreme Court has said it, then any court that we go into in a trial court has to follow that. Okay, so it's both going to be binding on us, and when we read the case, it's going to give us the full story. We can see how that relates to the situation we're involved in. Okay, so again, it's all in writing, and we file what we call an appellate brief. And you can see what the pieces of the appellate brief are. So initially we'll say what the facts are, what situation led to this lawsuit, what happened in trial, what the procedures were, what the court did and didn't do. Because to win an appeal, we have to show that the trial court did something wrong, and it had to be something wrong that affected the result, that would have changed if the court had done it right. Then the appellate court will tell us what the law is, and we'll put that in our brief as well. We'll say we think that the law should be X or is X. And then finally, the appellate court, we ask the appellate court to give us our result, reverse a judgment, change something, etc. So this is what we're asking in the papers that we file with the court. Now, when the court issues its decision, it's going to say the same things back to us. So it's going to tell us what the facts were. It's going to tell us its view of what happened in the court below. It's going to tell us what it thinks the law is. It's going to apply the law for us, and it's going to tell us what the result is. Okay. So, again, only appellate cases for the most part are reported in the states. Some states will report selected trial decisions, and in the federal court there are selected trial memorandums and things that are published. For the most part, when we're talking about a case reporter, we're talking about appellate cases. So we're talking about cases that have been appealed and follow this general pattern of giving us the facts, proceedings below, what the law is, how the law applies to that particular situation, and what the result is. Okay. Most states have their own official reporter. So Hawaii Reports was published by State of Hawaii, and there are unofficial reporters as well. So there are private publishers that publish cases. And there's some reasons why we have private publishers in addition to our official reporters. One thing is, generally, the state publications take a little longer to get published. Some states have actually done away with their official reporter. Their official reporter is now published by a private publisher, and that's true in Hawaii. Our official publication is now published by West, a private publisher. Okay. So, again, the official reporter, you can see here, United States Reports, published by the U.S. government. There are many, many other places to find a U.S. Supreme Court decision. So it's published by a number of private publishers, probably 10 very well-known places to find it, and another vast number. Nowadays, it even appears on the internet within a couple of days. So we can find these cases very easily. Okay, the unofficial reporters, the major system here is called a regional reporter or a national reporter system, and this is published by West Publishing. So I'll give you just a real quick and dirty background. John West, back in the 1880s, was one of the first people who decided to publish what the courts decided in a recognizable format. And so he started out, I think, in Minneapolis, and very quickly his reports were found to be very reliable reports, very complete, and in a format people could read and understand. Why was this a big deal? Well, previously, cases might be reported in the newspaper, they might be written up by different people, so there was not really any consistency. You might not get all of them. So the judges trying to follow what had gone on before kind of had a problem keeping track of what was going on. So when the reporters first started to get consistent, reliable, regular, that was a big deal. And so West now covers the entire country with what they call their national reporter system, their regional reporters. So in addition to finding our case in Hawaii Reports, we would find our case also in a publication by West. And that would be our regional reporter. And in our case, makes sense geographically, we're in what's called a Pacific reporter. That covers a number of states. Okay, and here's just a quick look. You can see that the regional reporters, you can see that the Pacific reporter covers, looks like 2/5, almost half the country. How come all the reporters are that way? Well, this originally started out population. Remember, it started back in the 1880s, and most of the West wasn't yet settled. So this is a big area. And so our reports in the national reporter system, our cases would be put in with cases from Alaska, Pacific Northwest, California, etc. Okay, so let's get to the nitty-gritty of how to read a case. Now, a lot of the business law textbooks and other textbooks, when they discuss a case, they'll just give you a piece of a case. So they'll just give you the holding, the important part, and it won't be in the context. You won't have the whole case. And of course, that's great when you're learning because you can just see the relevant part. But I'd like you to be able to read a case so if something comes up, you would know what that looks like and you can see it and find it, even though somebody hasn't extracted the piece for you. So start out with the obvious. We start out with the name of a case. This is done by using the name of the plaintiff, the person filing the suit, and on the other side, the defendant. So this is where we see the term versus, which means against. The plaintiff brings the case against the defendant, and in the legal terminology, we abbreviate that V. Okay. A lot of rules about how to put together a case citation and how to do the names, etc. But simple rule is when individuals are involved, you have the last name of the first plaintiff and the last name of the first defendant. Okay. Then we have a citation. Citation is simply our reference. So this tells us if we want to find this case, where we find it. So this is like you would put in normal bibliography, so to speak. But it's very important in the law that we be able to find the original source. So it tells us the reporter or reporters that we can find this case in. So if we look at a quick example, okay, you can see the top of this is our case citation. Okay, proper citation would include the name and everything else, but this is the part that tells us the reporters. So 67 HAW 549, comma 696 P2D 839. These are two different reporters where we can find this particular case. So the 67 is the volume of Hawaii reports. So there's a set of books called Hawaii Reports that report the decisions of the Hawaii Appellate Court. And we go to volume 67, and the 549 tells us the first page. Okay. Now, the second part, P second, is another set of volumes, and this is our unofficial reporter. So this is telling us go to Pacific Reporter, go to volume 696, and our case will start on 839. So two different places to find the same case. One is the Hawaii Reports, and a second is the regional reporter. Now, in Hawaii, all of us would have Hawaii Reports if we do legal work. However, we would not necessarily have Idaho Reports or whatever. In those cases, we would use a regional reporter. So many state firms and attorneys would have their own set of reports, but they would use the regional reporter to look for cases outside their area. Okay. Now again, if we're stating the case, you can see there are two plaintiffs, two defendants, but we would simply call this Kaema versus Aguilar, so we would simply use the first names. Okay, well, let's take a look. This isn't a case, and I'm just going to give you pieces of it. This is posted on the site so you can see the entire case, but I'm just going to give you an idea of what we would expect to find in the appellate case. So it starts out, it's going to tell us the facts. So this particular case is landlord-tenant, and it tells us who the parties are, a little bit about the situation. So it tells us the background, what happened that led to this lawsuit. This is a real critical piece when we are looking at cases because we are looking at cases to see if there's a situation like ours and to see how the court applies the law. And that's going to be useful to us because now if that case is like our case, we know that courts will decide it the same way, so that's going to be useful to us. So we're looking to find a case pattern, a case situation similar to ours. Next thing the appellate court's going to do is they're going to tell us what happened in the court below. So they're going to tell us when the lawsuit was filed, the trial did this and that, the jury heard this, the judge did that, etc. So again, just a quick little snippet of this. Apparently the landlord put the tenants out of their premises. Okay, and the question is, are they entitled to damages? Okay, after we look at the proceedings, then the court will discuss what the law is. It will discuss in general, what law do we think applies to this particular situation? Okay. Now, the little piece we've got here talks about statutory interpretation. So they're saying, in interpreting the landlord-tenant code, we're going to look at what the legislature's intent was, and we'll implement that to the fullest degree. But of course, first, we will simply look at what the statute says. Okay, and then we will look at a conclusion. So we will say how the law applies in this particular situation. So their finding here is that the language of the statute is clear. There's nothing that appears to change that. So the court didn't have any ability, any discretion to decide something outside the law. And so the appellate court is going to vacate, throw out part of the lower court decision and send it back to have a new judgment entered. So typically what happens at the end of an appellate case is, after they've discussed all of these matters, including the application of the law, they will tell the court what to do or issue a decision. And they will affirm, saying the trial court was correct. They will reverse, saying trial court was wrong, or they will remand when the trial court needs to do something. Might be a new trial, might be, in this case, entering a judgment consistent with the appellate opinion, etc. Okay, I want to talk a little bit about some things West has added. As I said, West started this a long time ago. They've been at it. They cover the entire country now with their reporters, and they publish these reporters, and they want you to use their reporter in addition to or in place of the official reporter. So why would you want to use West publication? Okay, they have some things they've added. So in addition to giving you the same opinion you would get in the original reports, they put in some extras, I think they call them editorial enhancements. So one would be a synopsis of the case. So right at the beginning, they would give you a summary of what's in the case. So this would obviously be useful to you reading quickly. They will give you some headnotes, and so they break down the case, and they will actually identify for you some points of law. So they've done some work for you, some research and some analysis for you, and they're giving that to you. And then they have what they call the key number system. And this is their index. They put the entire body of law, American law, into an index system with numbers to help you navigate and find particular points. So let's look at those briefly, how those might help us. Okay, so again, this is the same case. This synopsis would not be in the official report. This has been added by West, the publisher. So this tells us what happened. This makes it real easy to understand. Tenants brought an action against the landlords, said they were locked out, and tells us what happened in the court, and finally tells us what the court did. So this is a real quick way, one paragraph. We can zip to this case, look at it, don't have to read the case necessarily to get an idea of whether this might be useful to us. So great aid if we're zipping through cases trying to find a case like our own situation. Okay, headnotes. Again, headnotes are a neat addition. What these are descriptions of each individual point of law that the editors have found in this case. So they have kind of sliced and diced the case. My understanding is they have it's looked at by perhaps 20 different lawyers working for the publisher. A number of different lawyers will look at this, and they will figure out each particular point somebody might be interested in, each legal point, and then they will assign it a headnote. Okay, you can see these are numbered consecutively, 1, 2, 3, 4, and they have a designation, a key symbol, and a number. Okay, now that number is part of the West key number system. So looking at the headnote, we can see this is a description of the law. So this is the part we saw earlier. about statutory interpretation. And this, again, has been extracted. This is a point of law that the editors have taken out of the case. So this headnote is not itself part of the opinion. It's just a helpful aid to us. It's something to assist us. We couldn't really rely on this as being what the court says. This is somebody's description and summary. Okay. Now, when we find a headnote that has a number, we can jump down into the case and find that same number, and that's where the editors took this headnote from. In other words, they've created this little index at the front, these headnotes, to tell us, kind of like a table of contents, what's in the case. And if we find one that looks interesting, then we will jump down into the case, and this is the actual case opinion. This is what the judges are saying. So they have extracted that for us, and we can use it to jump into the case since they've used the number down here to get us here. Okay, again, the key number system, they've divided the entire body of American law into major subject areas: persons, property, contracts, torts, crimes, etc. They've further divided it into topics, and then they've gotten down to the individual concepts or points of law, and they've given each of these a number. So the beauty of this is, if we find a point of law that's of interest to us, that same number will be attached to that same point of law across all of the publications. So if we find a California case that has a particular key number, we can take that key number, check it in the Hawaii system, and see if it appears in a Hawaii case, and vice versa. So once we find a number that's right exactly what we're interested in across the country, we can use that particular point of law in West publications to find similar cases of use to us. Okay, so in our example here, the key number is Statutes 188, how to construe a statute. And you can see you're going down the different levels to the very specific point of what they first look at. So that's how that's useful to us, is identifying and finding the same point in other cases. Okay. Now, I hope you've been able to see that when we apply cases to statutes, how that's useful to us. Statutes in general are written very broadly. We're talking about prospective activities. It's not possible for the drafters to list every possible situation that might or could be covered. Cases, however, only come into play when there's a particular situation. So somebody's actively involved in a problem or a dispute, they take it to court, and now the court has to take the broad law and apply it specifically to this particular fact situation. So we have an application and interpretation on a real practical level. It's something right in front of us. We need a decision. So there's nothing theoretical about it or perspective. It's being applied to this situation. Okay. Now, over time, we're going to have a number of decisions that will help us understand that specific application. So, for example, on the beach trash, we now know that intent doesn't make any difference. We might have future interpretation that tells us what trash means, whether the value is involved, and we might have other cases that tell us when we say beach, we mean X. Okay, so particularly in something as vaguely written as the trash beach ordinance, we might need a lot of interpretation, and hopefully that would be a little bit fixed with our definitions, but we would still need court interpretation simply because we're applying a broad statute to different specific situations. Okay, I hope you have now gotten an idea of how we apply the cases and use them in interpreting the statutes. We will be using a number of cases as we go forward and coming back to see how we do that interpretation. I'd like you to look at the online materials on the Laulima site. And for next time, we're going to be looking at ethics. So we're going to get into applying law. We'll see the differences between law, ethics, morality. We'll see what business ethics are, and we'll see how that affects what we do as well. So this is Ben Carroll saying aloha from BLAW200. See you next time.